right, Ken, it's all yours, bud.
Okay, sounds good. Hi, everyone. I hope everyone's had a good year so far. It's hard to believe that it's almost halfway through September. Hard to say what happened to 2023, but I didn't hear the earlier part of your sales meeting, but obviously things will slow down a little bit just because of the interest rates. Hopefully they're putting a pause on those for a while. Just for any of you guys who don't know us, we do a lot of real estate. We've done real estate for 25 years. We've done tens of thousands of deals. So as Michael said, if you have any questions, you have a legal question on any file, feel free to call me or email me or Melissa, who's the other lawyer in our office, and we're happy to chat with you. 9 times out of 10, we can just answer your question. We're not going to send you a bill. If we can help you out with something before the contract becomes final or before you draft it, feel free to give us a call anytime. That's 24/7. So if you send me an email on Saturday, you'll probably get a response on Saturday or Sunday. So without anything further, Doug has asked me to have a chat with you guys about assignments of contracts of purchase and sale. You probably know that basically most contracts are assignable. Your regular everyday contracts used to be assignable all the time until 2016, when Christy Clark decided to put that clause 20A into your contract, which says contracts are now not assignable. That was a waste of time. It didn't do anything for anyone. It just complicated your files. But in any event, having said that, these type of assignments that we're going to talk to you guys about today, this has been going on for 25 years, these assignments of pre-sale contracts. So I guess what I would start with, that's what it says. If you're looking at the PDF copy, it says assignment of contract of purchase and sale. So let me ask you guys, anybody, what's an assignment? Anybody?
Well, that's
taking ownership of someone's deal.
Sorry,
it says contract selling.
Contract selling, yeah, pretty much. So an assignment is a transfer of something. Okay, so when we think of a transfer of a car, transfer of property, we usually call that a sale. So like I said, it's an item. When you're assigning a right, we usually call it an assignment when you're transferring a right. So I have a right to buy this pre-sale contract, and let's just use my example. We'll say Doug's going to buy this pre-sale, and Michael's going to take the assignment. So he's going to take over Doug's right to buy the contract, let's say from Boza Development. So that's an assignment. And if you look at clause 5 on page 2 of that document you guys hopefully all have, it says the assignor hereby assigns to the assignee as of the effective date all of the assignor's right title into the contract on the following terms. So in other words, that's exactly what it is. It's a transfer of an interest. In this case, the interest is your ability as a buyer to buy this pre-sale contract. So if we look at the first page, it's an okay contract. It's pretty cumbersome, but I think if you guys look at an assignment as 2 separate deals, it'll make more sense to you, because every once in a while people try to throw everything into the same document, which is kind of what this one's done, and it makes it more confusing. So the fact is there's 2 transactions in this particular assignment. One of them is between the assignee and the assignor. Okay, so in my example, Doug was going to buy the property from Boza. Michael's going to take over the contract from him. Okay, so that's one part of the transaction. The second part of the transaction is Michael's going to buy the property from Boza. Okay, so there's 2 deals going on here. There's 2 sets of statements of adjustments. There's 3 lawyers involved. There's Boza's lawyer. There would be us if we're acting for Michael, and then there would be a lawyer acting for Doug, who's going to hopefully get the balance of the money at some point in time on this deal. So if you look at it 2 ways, there's two deals going on here. I think it'll make more sense to you. So if we go down the page, the assignor, so in this case, the person who's the original buyer, that's Doug, that's the assignor. He's going to buy this property from Boza if nothing else happens. The assignee is Michael. He's the guy taking over the rights from Doug. Okay. In number 2, we'll just say number 2 is Boza Development. Okay, so the developer. So we're going to fill in the details in the contract. So as you probably all know, any of you who've either done one of these, or maybe you've bought your own pre-sale, or you've helped the client buy a pre-sale, when you enter into a pre-sale contract, there's always a disclosure statement. Okay, so the disclosure statement is prescribed by law. It used to be by FICOM. I think it's at BC Financial Services Association. It's required, and so that what the disclosure statement basically says that it gives you a general idea of the development, what's in it, how many stories it is it a condo development, is it a townhouse development, is there a commercial part of the development, is there parking, et cetera, et cetera. So disclosure statement can generally go anywhere from 30 or 40 pages, sometimes up to 100 pages, and sometimes there's 2 or 3 amendments. So basically, where you're going to check off this box here in clause number 2, disclosure statement, yes, there's always a disclosure statement. So was it provided by the assignor to the assignee? Again, you're going to say yes, because you're going to do that. So the assignee, remember, he's taking over, in this case, Michael, he's taking over Doug's position. So of course, he's going to want to see the disclosure statement. And sometimes there's 1 or 2 or 3 or 4 amendments to the disclosure statement. So I've had a couple of cases where we've reviewed these for people, and they can be like 300 or 400 pages. So they can be pretty substantial when there's quite a few amendments to the disclosure statement. So again, for any of you guys who haven't seen a pre-sale contract with a developer, they are nothing like your normal contracts that you guys are used to dealing with. They are 100% in favor of the developer. Basically, the buyer has the right to buy the property. That's it. Beyond that, every other option, every other term in that contract is for the benefit of the developer. So keep that in mind. Next, we have the disclosure statement checked off, yes. We have the amendments checked off, yes. And then it says, is there a deposit protection contract in place? Okay, does anybody know what a deposit protection contract is? Guys, no? Okay, so when you guys write a purchase agreement, a regular one, and somebody makes the deposit, what happens to it? Where does it go?
Held in trust.
It's held in trust, usually by your real estate brokerage in your trust account. And when is that deposit ever released?
When the deal closes.
Complete.
When the deal closes, exactly. It becomes part of the purchase price. Some of it may go to pay the real estate commission. The rest will go back to the buyer's lawyer, and he'll close the deal with it. However, in the case of a pre-sale, most developers, like in this case, Boza, that money is not going to be held by you guys. It's going to be held in their lawyer's trust account. So again, they may be 200, 300 of these deals closing, and they've got millions and millions of dollars in trust. So normally, in the real world, that money stays in trust, and it's going to get released, just as you said, on the completion date. But in this case, the developer has the option under this act called the Real Estate Marketing and Development Act, REDMA, to basically take those deposits and use them toward the purchase price. Whoa, that's kind of scary then, because what happens if they don't close? You've used my deposit, now what? So they have to, by law, enter into an agreement with an insurance company to get a deposit protection contract, which means that if the developer at the end of the day does not close, does not make the title available to a buyer, then this insurance company will basically reimburse the deposit to the buyer because it's gone, the deposit's been used. So it's been replaced by a deposit insurance protection contract. So that's what it is. Sometimes that's done, sometimes it's not done. Sort of depends on the developer, how deep their pockets are, whether they want to use that money or not. But you'll be able to find that out if there is one. So we go down further to the contract of purchase and sale. So this is original contract. This is, in this case, between Doug and Boza. So you're going to put in the date, you're going to put in whether it's been amended, whether there's upgrades. So again, maybe the contract purchase price is $1 million, but we've added an extra parking stall, we've added some fancy stuff. and then we're going to put in the amount of those upgrades. So it's no longer $1 million. It's actually say $1,010,000 because we've added some extra stuff. Again, the buyer's going to obviously, Michael in this case, will want to know that. Then the deposits, as I say, they're normally held by the law firm that is acting for the developer, which is typically one of the big law firms downtown. And then here's an interesting one. Okay, so how much was the deposit? So let's say in my example, $150,000. You got $1 million purchase price. Somebody's got $150,000 in trust. There's no deposit protection contract, so the money's still sitting with, let's say, McCarthy's downtown. Then it says here, is any portion of the deposit secured by a bond? Okay, does anybody know what a bond would be used for as far as a deposit goes? No? Okay, so
Insurance company.
so 20 years ago, when these pre-sales really started taking off after 9/11, people were buying two. I don't know if you guys remember, some of you may go back this far. There used to be lineups around the block. You know, there's people would even hire someone to stand in line overnight so they could get in and buy a pre-sale. So this is how crazy the market has been from time to time. And so when you buy a pre-sale, typically there's a 2 or 3 tier deposit system. So like you put down 5%, then you say 30 days later, you put down another 5%, and then maybe a few months later, you put down another 5%. And so these things are sort of spread out. And so if you want to buy multiple pre-sales, you say, well, gee, I don't have that much cash. You know, maybe I can't, my line of credit's tapped out. Could I just get a bond to give to the developer in place of a deposit? That's what this is. Okay, they're not really that common anymore. They were used quite a bit in the early 2000s, but I haven't seen any lately. But all that bond is just basically you buying a bond. Let's say for $25,000, you maybe pay a premium of $1,000, $1,500 to the bonding company, and then you provide that bond to the developer. There's my deposit. Okay, so guess what? If I default, the developer is going to call on that bond. The insurance company is going to pay the developer the deposit, and then they're going to sue you for it, because that's what it is. Again, not very common. I'd say right now, 9 out of 10 times, maybe more, it's going to be no. Is there a bond in place? Very, very rare these days. And then it says, who's getting the interest on the deposit? The developer, all the time, 100%. So there's just no idea that anymore that the buyer gets, or in this case, that Doug would be getting the interest on his deposit. No, not going to happen. And the interesting part of that is now that the interest rates are a little bit higher, so we'll say Doug's deposit was, what do we say it was, $150,000. So it's going to sit there for 3 years, $150,000. That's a good little chunk of interest accruing to the in this case BOZA. Okay, next clause on the first page, it says, does the developer have to consent to the assignment? Always, 100%. Absolutely no situation ever can happen where the developer is going to allow assignment of a purchase contract without its consent. Simply not going to happen. It's going to be set out crystal clear in the contract. If you think you're going to sign it and not tell the developer, you're just not going to close. Okay. Okay, what else do we have in here? Developer's assignment fee. So again, if you go back to clause 20A in your regular contracts, usually somebody assigns the contract, the seller says, oh, it's okay, it's your brother, your sister, it's the guy next door, I don't really care, sure, go ahead and do it. It's not that often that the seller says, okay, you can assign it, but I want a bunch of money. Okay, so even though clause 20A says you're the assignee, or the seller is entitled to any profit, there's usually no profit, and people, like I said, generally don't flip houses, so it's not that common. But a developer always charges a fee. Okay, the lower ones are 1%, but I've seen them as high as 3%. And that assignment fee can be on the original purchase price, or it can be on the assignment price, which could include a lift. We'll get to that in a minute. So let's say in my example, the assignment fee is 2%. So we're talking $1 million, 2% on that is $20,000 assignment fee. That's what, in this case, Doug would have to pay to BOZA in order to allow that contract to be flipped over to Michael when the deal closes. Okay, so if we go to the next page, again, we just go back to clause 5. That's what we're doing. We're signing the contract. In my example, from Doug to Michael. Michael's going to be the new buyer. So then clause 5.1. This is an interesting one. What is the assignment amount? Okay, so how does this thing work? Remember, we've got a couple of different balls in the air at this point in time. So Michael is going to be buying the contract from Boza for $1 million. Okay, so that's fine. So what does clause 5.1 says? Michael is going to pay Doug. In this case, my example will be $250,000. How do we come to that? $150,000 to reimburse his deposit because Doug put down 150 grand over time. Boza's lawyer's sitting on that in trust, and Michael's going to take over that contract. So Michael's going to assume that credit of $150,000. So he's going to have to pay that back to Doug. And then number B, that would typically be what we call the lift. So what is a lift? That's the profit that Doug is going to make on this contract. Now, keep in mind, in certain times, really for the last 20 years, the lift has normally been positive. I can only think of 1 or 2 cases where the lift has been negative. So if the prices have gone down and I'm having a problem closing, let's say Doug is saying, oh man, I'm kind of a bit of short on cash. I don't know if I can close. And the property value has gone down a little bit too. Now, all of a sudden, Doug is actually saying to Michael, you know what, I'll give you some money. You can keep some of my deposit yourself. And the lift is negative. Again, that's pretty rare. It does happen from time to time. But in my example, we're going to say it's a positive lift of $100,000. So Doug is going to walk away with 100 grand at the end of the day after this whole thing completes. So then the assignment amount, according to the way this contract is drafted here, the assignment amount is the deposit plus the lift. So that'd be $250,000. Okay, so that's basically that's going to go back to Doug at some point in time, depending on how this contract is drafted. So again, 150 grand, that's just giving Doug back his deposit. $100,000, that's his profit, or what you guys would call the lift. And then at number D says, okay, the assignee's total purchase price, which is the original purchase price plus B, which is the lift. So again, in this case, it'd be $1,150,000, or sorry, $1,100,000, because the full price to the buyer, which is Michael, he's going to buy the property from Boza for $1 million. He's going to give back 150 grand to Doug, but again, he's going to get an offsetting credit with the developer, so that's kind of a wash. But then he's going to pay another $100,000 out of his pocket to give Doug his profit. So next item down, there's a deposit. There's a deposit that's paid on this assignment contract. Let's say it's 50 grand. So again, when all the conditions are met, that deposit is going to go into someone's real estate trust account. That's not going to go to the developer. You guys are going to hold that in trust.
Hey, Ken, just to hold you up a little bit there.
Yep.
When we're working for the buyer, we don't like to hold that deposit. We like them to give it to you.
Fine.
Or the lawyer, because the only thing is that withholding tax, we're not set up to deal with it.
Yep.
And if it says in their contract later on that we pay it directly to the assignor, then we're kind of liable for it. So what I tell our guys is always pay it to the lawyer, use the lawyer to close, and pay it to the lawyer.
Not a problem. You can do it either way, however you guys like to do it. It'll say in here who's holding that. And whoever's holding it, whether it's you or us, we're going to hold it as what's called a stakeholder. So in case you guys don't know what that means, hang on, just excuse me one sec, guys. I sort of do this, but I just got to go away for 1 second.
So make sure, guys, that when you're working on the buyer side, when you put who's going to be the stakeholder, it's the buyer's lawyer. Have the buyer get a lawyer, have them pay the deposit to the lawyer directly. That's okay. That's part of the thing. Then what happens if later on in the contract, it'll tell you how it's all going to be paid out and when the assignor gets the money and all that. And sometimes they'll want their lift or their profit up front And in part of the contract, it'll say it that whoever the stakeholder is pays it directly to the assignor, and that gets us out of the way. We're not in for taxes. Lawyers have all the forms that they need to assure them that they're not from out of country and whatever. Sorry, Ken, just jumped in there for you.
Yeah, no problem. So just to let you guys know what a stakeholder, it just means the person, in this case, the real estate brokerage firm or us, we're holding that deposit for the benefit of the contract. We're not holding it for the seller. We're not holding it for the buyer or the assignee, assignor. So bottom line is, if the deal doesn't close, at the end of the day, we're going to, it's going to go back to someone. It's going to get paid into court. We just can't release it to one party or the other. It's what a stakeholder is. So even when you guys when your brokerage firm holds a deposit on a regular deal, as a stakeholder, that's the way it is. You've got, hey, fine. That's the way it is. So back to clause 5.2. So that's fine. You guys can send us the money and we'll hold it as a stakeholder. Then clause 5.3, basically that's the terms and conditions you're going to put in, just like in any contract. These are like, you never make these assignment contracts with no subjects. I've never seen one like ever. So you're going to put in clauses like, you know, obviously the buyer's going to want to review the original contract. So Michael's going to say, okay, let's see your original contract with BOSA. And by the way, I want to see all the disclosure statements and all the amendments, because I want to see what's going on in this transaction. Maybe I want to put in legal advice. So I want to talk to my lawyer and see what he thinks about this agreement, whether there's something missing or whether we should add something to protect me. And financing. So again, this financing, same thing, is in this case, Michael's got to be able to buy it, unless he's got a whole bunch of cash sitting around. He's going to make sure his bank has got an appraisal on the property and say, yeah, it's worth X, you can borrow Y, and away we go. So those are kind of your normal type of conditions you're going to put in there. You could also put in subject to the developer's consent, but it's in the rest of the contract, but you could say that too. You don't get the developer's consent, you don't close. It's very simple on that. So again, terms and conditions, they're important to in this case to Michael for his protection as a buyer. So if you go to clause 5.4, just talks about the assignment contract or the assignment amount. It's going to be paid by bank draft. Everything gets paid by bank draft nowadays. Very few certified checks left in the works, and generally it's going to get paid within a very short period of time from the time of the effective date. And so you say, okay, what's the effective date? We'll get to that in just a minute. That's clause 5.7, but we're just kind of moving down. Developer's assignment fee. So who's going to pay the assignment fee to the developer? Anybody?
Negotiable.
Well, it's negotiable. Yeah, I would say 9 times out of 10, it's going to be the assignor, which is, in my example, would be Doug. He's the guy making the big lift. He's going to pay that 2% to BOSA in my example.
The first owner.
Yeah. Sorry.
The first one buying the condo or whatever.
Yeah.
Not the new buyer. The first
That's
buyer.
right. That's
original
right.
buyer will pay.
That's right. Yeah, in my example, Doug, your manager there, he's the buyer, and Michael, he's going to be taking it over. So in this case, Doug would be paying the assignment fee because he's going to presumably make this $100,000 profit, and he's the guy asking the developer for consent to do this transaction. In my experience, 99% of the time, the developer is going to say yes to an assignment. Why is that? Anybody have an idea why developers almost always say yes?
Because they make money.
That's right. In this case, he's going to make an extra $20,000, and both parties still stay on the hook to buy this property.
Yeah,
okay, so
they want to complete.
So let's say Michael defaults, something gets hit by a bus, whatever, he can't close. Guess what? Doug's closing. Okay, he's still on the hook right until this deal closes. He could theoretically be drawn back into the picture, and he's got to close. Okay, so that's why a developer typically There's no downside for them to, it's just some extra paperwork. They've got to fill out a bunch of forms and send them into this assignment registry for condos. But the fact is, that's not a $20,000 expense. That's a $500 expense, maybe $1,000 at most. And so the assignment fees, like I said, they can go from 1%. I've seen them 3%. I've even seen a few 3.5%. So yeah, the developer's now got 2 buyers on the hook, plus he's got an extra $20,000 in my example. So yeah, it's very rare. The times when a developer will say no, though, is you have to look in the contract. So the first thing you do is look in the pre-sale contract, because sometimes they put in some conditions. It's always completely at their discretion, but a lot of times when it's closing, say in a month or less, they go screw it. There's no more assignments. We just don't have the capacity to mess around with assignments. So no more assignments. You buy it, you can resell it. So again, always check if you're starting one of these things. First thing you may want to do is give the developer a call and say, okay, well, are you allowing assignments from now? And if so, how long you're going to assign them? Because trust me, you're not going to do an assignment a week before closing. Okay, that's not going to happen. Okay, because these developers and their lawyers may be closing 200 or 300 of these more or less on the same day. They don't have the capacity to start, changing everything around. So don't wait until the last minute if you're thinking of doing an assignment. Okay. Okay, then clause 5.7, that's an important one because it says, well, when does this assignment become effective? Okay, it's called the effective date. And basically it says this assignment will be effective on the later of the last date of any conditions set out in 5.3. So again, there's your subject conditions, the financing, review of the contracts, review of the disclosure statements. That's one day. And then the other day is the date the developer consents. And then the third option is some other date that you just arbitrarily picked. So once you remove the subject conditions, you've got the developer's consent, the effective date says, okay, bang, this assignment's in force. It's effective. So then the next item, clause 5.8 is a fairly important clause. And because there's 3 different options and they're all different. And some of them benefit the assignor, some of them benefit the assignee. And the third one's sort of a trade-off. So the first one is option A. So that one says assignment amount released on submission for registration. So remember we said the assignment amount was the deposit that's going back, in this case, to Doug, and plus the $100,000, his profit, the lift, that's going to Doug. When does he actually get that? That's what clause 5.8 talks about. So option A is actually the best one from Michael's point of view. He doesn't get anything until we close, until Michael buys the property from Boza as the assignee. Then when it closes, Doug gets everything. Okay, so that one usually doesn't fly. As far as Doug's concerned, like, screw that, I'm not going to do that. Clause B is just the opposite. Clause B this would be for Doug's benefit, for the assignor. Basically, as soon as the subject conditions are removed and the developer consents, he gets everything. So he gets his deposit, plus he gets the lift. So, okay, and furthermore, if you read the rest of clause B, it says, even if the developer never closes, guess what? Doug doesn't have to pay Michael back the lift. So that one doesn't fly very often either. I've had some clients, saying, well, should we do that? I said, no, I don't care. Boza probably will close, but if they don't, then in my example, Michael's out of pocket for $100,000 and Doug's flipped the condo. He's got the money, and guess what? The deal never closed. So will Michael get his deposit back? Yes, because that's either sitting in trust or there's a deposit insurance contract. So he's going to get his 150 grand back, but he's paid Doug $100,000 for nothing. Okay, so clause B is not really one that gets used very often either. Clause C, which is on the next page, is the most common one. So when the conditions are removed, the developer consents, Doug gets his 150 grand back. Okay, so here's your deposit. So there it is. You're not out of pocket at all. And then when the deal closes, when Michael buys the property from Boza, then Doug gets his $100,000. Okay, which is fair. That's kind of a compromise. He should get his deposit back because now Michael's taken that over from the developer, with the developer, and Doug should get his money when everybody else gets paid. Okay, which includes the realtors. Okay, and then again, 5.9, talks about interest on the deposit. As I say, that always goes to the developer, which doesn't seem fair to me, but that's the case in most situations. And then clause 5.10 again talks about a deposit protection contract. All it basically says in 5.10 is the assignor, in this case, Doug, is not going to make any claims on that contract because he's not really an owner anymore. He's out of the picture. Clause 5.11 talks about disclosure statements. Make sure that the assignee has a copy of the disclosure statement. Why is that? Because if people don't have the disclosure statement, they can always terminate the contract with the developer. And that's the last thing the developer wants, is somebody just walking out of the deal, getting their deposit back, and there's no remedy for the developer. And I've actually had a case like that a few years back when they were building Olympic Village. My client actually didn't get a couple of the disclosure amendments. They were just never sent to him. The one that says you need a copy of the building permit's been granted and financing has been approved. When that happens, that has to happen within a year, and it didn't happen. So we actually terminated the contract, a year and a half into the contract, got the guy's money back. The developer was not happy about it, but it was their fault. So in this case, it's saying right here, yes, the assignee has got the disclosure statement, so he's not going to come back later and say, I didn't get it. And then 5.12 talks about an indemnity. So again, my example, remember I said earlier, what happens if Michael doesn't close with BOZA? Well, guess what? Doug's having to close. Okay, so maybe Doug doesn't have any money. He's used it up. He's got other plans. Well, now basically Michael's going to have to indemnify him for any losses because Doug's getting pulled back into the contract to close, even though he wasn't counting on that. And then there's basically in this case, Michael would be saying, yes, I'm going to close. I'm going to close according to the contract, and I'll indemnify Doug if I don't. Okay. Again, that doesn't happen very often. I think we've only seen one case where an assignee didn't close and the assignor end up having to close with the developer. It's very rare. Okay, an important one here is clause 518, goods and services tax. Okay, so what does that mean? People, a lot of times people say, well, what's the GST implications of an assignment? Okay, so remember, when Michael buys this contract, this property from BOZA for $1 million, he is going to pay GST on $1 million. Okay, so there's $50,000 GST he's going to pay. BOZA is going to collect it and send it to Revenue Canada. What about on this assignment agreement? What about this flip for $100,000? Doug's making $100,000 profit. Where's the GST on that? Well, this contract by default says that GST is included in the $100,000. Okay, so just by paying that $100,000 to Doug on the completion date, that's include about $5,000 worth of GST. So then Doug has to remit that money to Revenue Canada. Okay, so that's his problem because it's a GST-able transaction. Now, about a year ago, Revenue Canada changed the law on this particular clause. So it used to be about a year and a half ago, let's say if Doug was buying this for his own personal use, he was gonna live in it. But then let's say he got married and had some kids in the 3-year hiatus between buying it and then closing. And now he's got a kid and he's got a wife and this was a 1-bedroom. Sorry, it's not going to work for me. In that case, generally, there was no GST on this transaction. This was a one-off personal use situation. You could argue to Revenue Canada, no GST on that, and there probably wasn't any. That rule got changed last year, and guess what? It's GST-able no matter what. Okay, so that's a change. The other change is that the GST that they used to charge on this was, believe it or not, this is how insane this was. The GST was on the lift plus the deposit. Now, how crazy is that? Because that's really not part of the purchase price. That's just reimbursing, in this case, Doug for the 150 grand. But the way CRA used to insist on it, nobody challenged them in court, and they should have, is they said, no, you're paying GST on the whole thing, on the so-called assignment amount, which in my example would be $250,000. which is $150,000 deposit plus $100,000 lift. CRA is taking GST on the whole thing. That was completely insane. I think it was wrong, but anyway, they got away with it for years. Last year, when they said, okay, everything is GSTable, we don't care what the circumstances are, they changed that rule and said, oh, by the way, we're just going to charge the GST on the lift, which is what they should have been doing from day one from the last 20 years, but they didn't. So now that GST is payable, but it's only payable on the lift.
Yeah, and I got a question there.
Yeah.
The GST on the original purchase price goes to the assignee, is that correct in this contract?
On the original purchase price, no, it goes to the developer.
No. The GST payable is payable, like the GST payable on the, to the, you know, for the original purchase price.
Yep.
Is paid by the assignee.
Correct. And in my
Does it
example,
say that in the contract?
yeah. This is like I said, he's just taking over the position of the original buyer. He's going to close with BOZA. He's going to pay the $50,000 GST to the developer's lawyer, and they'll send it to CRA.
Because kind of what I've been recommending is that, you know, in these terms back on the other page there, that they put explicitly who pays what. So there's no, you know, no miscommunication that the buyer of the assignment of contract or the assignee is going to pay the GST on the original amount, and the assignor will pay GST on the lift.
You could, if you want to throw that in, you can for clarification's sake, but
Yeah, because
you don't-
for most people don't know who's paying what now, and there could be some gray area there when it goes to you. Then no, I didn't think I was paying that, and I've had one of the realtors forfeit her commission because of the GST, and the assignee had to pay it. She didn't think she did for some reason.
the assignee didn't think she was going to pay GST to the developer.
Yeah, she thought the GST was included in the purchase price of the assignment of contract.
I see. So that's that. I mean, but without that, let's say you don't put anything in the contract, she's completely out to lunch. Like there's no way she would have no legal argument to make that claim. But if you want to put it in just for, like I said, remember this is two transactions. This is why I said people get confused. They go, oh, isn't the whole thing included in this assignment? No, the assignment is one contract and the other contract is the guy buying the property from the developer. So is to say when you separate the two, there's less confusion. Because you're thinking, well, gee, I'm buying this from BOZA, but I GST free. Wow, that's pretty good. That's 50 grand in my example. Wow, that's a good deal. Whereas the GST on the lift is only 5,000. So that's included pursuant to this clause in your contract 5.818. It's generally a way lesser amount than the GST on the purchase price. So nothing wrong, Doug, with putting that in, just crystal clear. Here it is, just in case you can't read. Yes, Mr. Buyer, in this case, Michael, you're going to be paying the GST when you buy this thing from BOZA. But if there's any GST, which there always is now, on the flip, on the assignment, yeah, that's Doug's problem. It's included in your contract. So yeah, that nothing wrong with putting that in. It's clear to me, but again, it's not necessarily clear to everyone. But if you put it in, then there's just less confusion. And the whole point of this thing is not to say, well, you're wrong legally, we go to court, you lose. How about we don't go to court? Is how about you know what you're doing to start with. So in that example that you just gave, Doug, the buyer should have had their own lawyer, went through the contract, went through the assignment contract and explained to them, guess what? You're definitely paying the GST on the purchase price. You're not paying the GST on the lift or on the assignment. Anyway, some people have these things reviewed by a lawyer, some people don't. But again, because I would guess the average person in your office does these once in a while. I mean, there's other firms like I know Rennie and Associates, they've made an industry out of doing these assignments. But so if you're not that familiar with it, definitely for all, you know, talk to Doug, talk to Michael, give us a call. You want to try and avoid the confusion for the buyer to say, well, what am I paying? Like, what am I actually paying here in my example? I'm paying the purchase price to BOZA, I'm paying GST on that, and I'm also paying an extra $100,000 over to Doug because he's flipping the contract to me. So this is again, this is sort of This is sort of something you try to want to make sure everybody's on the same page. Another thing which trips up buyers quite a bit is the property transfer tax. So, okay, remember we said, okay, Michael's going to buy this thing for $1 million from Boza. Okay, so he's going to pay GST on $1 million, which is $50,000. What about property transfer tax? What is he going to pay the property transfer tax on? Is he going to pay it on 1 million, or is he going to pay it on 1,100,000? What do you guys think?
Well, knowing the government, it's on everything.
Exactly. You're correct. The purchaser, the new purchaser, this example, Michael, he's going to pay property transfer tax on 1.1 million. Okay, so just extra few bucks there, just to throw on the pot. So you're right. Knowing the government, that's exactly what they do. If Doug bought the property himself and he never flipped it, he would pay property transfer tax on the original purchase price. He would pay GST on the original purchase price. So there's a difference here between GST and property transfer tax. One is federal, one's provincial. So the federal one, everything stays the same. The provincial one, now we want an extra cut. So we're basically going to take the property transfer tax on the assignment amount, not on the original purchase price, just so you know. Okay, goods representation of the warranties is again, so anything's important. You guys always have this is in your regular purchase agreement as well, clause 520. So there's any separate promises, any sort of things that are important to you, make sure you put them in the terms and conditions, because again, what it says here, if it's not included in the contract, it doesn't matter. That's the same thing if you're buying a pre-sale. They have a big clause in there, and usually toward the end of the pre-sale contract, it says, yeah, no warranties, no representations, don't rely on the brochures, don't rely on any of the marketing materials, don't rely on anything we told you. It's not in the contract, forget it. Us developers play hardball with you when they close, and that is just a given. I don't care if it's Boza, Ani, Polygon, Pinnacle, doesn't matter. They play total hardball with you when you close. So don't something's important to you, you have that extra parking stall, some color scheme, whatever it is you think you're going to get, put it in the contract. You want side-by-side parking stalls, put it in the contract. Otherwise, you can get parking stalls that are on different levels. You want a full-size parking stall, you put it in there. You want an EV charging station that's included, you put it in there. If it's not in there, your chances are you're not going to get it. And again, as in my example, Michael, he's going to take over that contract. So that's why he's going to read the contract and say, okay, there were supposed to be 2 parking stalls. How come it doesn't say the second one here? So then you got to sort that out before the assignment contract goes ahead.
And we had a case where the original purchaser bought an extra storage locker and then forgot to give that to the our listing realtor. And when the assignee went to close, the surprise was they found that they had an extra storage locker they had to pay 10 grand for, whatever it was. They said, we didn't order this, we didn't know anything about it, we're not buying it. But like you said, the developer said, no, you bought the contract, you're buying it.
That's right.
So the assignee was going to sue our guy because, you know, but I don't know what do you think of that? I mean, it's really the owner's fault, is not, or for not providing the proper documentation.
Yeah, totally. In fact, yeah, I mean, again, that should have showed up on the first page of this thing where it says like extras. What extra did you order? It could be an extra, you know, fancy kitchen countertops, but it could also be an extra parking space. So yeah, it's really a problem by the original seller. Now, again, if you say, well, I'm going to sue you, that's a tough one, because you're suing me for what? You've got an extra parking stall, which is presumably worth 10 grand, or an extra storage locker. So
yeah,
I mean,
it was a mess.
Yeah, I know. They're always a mess when these things come up at the last minute. Okay, the last thing on this, guys, is this thing on the very last page of this document. It's the developer's consent. So here, this is actually an okay document. It's called developer's consent to assignment contract. It's got ticks all the boxes off. I have never seen a developer sign this form, ever. Okay, so they have their own form. They have a different form, which says more or less the same thing, but not everything in here. And that's the one that in my example, Doug, who's the assigner, that's the one Doug's going to sign. Okay, not this one. You can give this one to the developer, they'll just throw it away. Just because they have their own customized stuff, they have their own customized lawyer. It's right on the very last, if you're scrolling down, it's the very last document. It's called Developer's Consent to Assignment. As I said, it covers all the bases, but it's not going to get signed. So the developer has its own version of this, and basically what it's going to say is both parties stay on the hook. So yes, I can sue both of you. If somebody doesn't close, too bad, you're both on the hook. Plus I get my 20 grand assignment fee, otherwise I'm not signing, and away we go. So just you know, like I said, keep in mind there's going to be a different consent form.
Okay, what do you do with this one then? Because it's part of the contract.
It just doesn't get filled in.
You just cross it out, or what do you do?
Just leave it blank.
Okay.
Because you're still going to get the consent. That clause 5.3, I think, is the one that talked about conditions.
Well, wouldn't you put a see attached addendum or something, or?
You could say, you could cross it out and say it could be replaced by, you could, cross it out and attach the developer's consent to it. You could do that. But one way or another, I mean, you have to get the consent, otherwise the contract's not. As long as the real consent signed by the developers in their own form gets attached to this, you're fine.
Okay, good.
So
Well,
it's a complicated sort of area, and if you don't do a lot of them, then a lot of times stuff gets filled in incorrectly. So it's always a good idea to say throw a clause in there subject to the seller and the buyer getting legal advice by a certain day, because that way then in my example, Doug can have his own lawyer take a quick look at it. Michael can have his lawyer look and say, okay, we forgot this, let's fix it up. So when this deal closes, like let's say the actual completion date comes up, let's say it's September 30th this year, and everything's all signed, sealed, Michael's ready to buy it, Doug's now just sitting on the sidelines. What happens on the completion date? Well, two things happen. Number one, we would act for Michael, we close the deal. So we deal with Bose's lawyers, we pay them $1 million plus the GST, property transfer tax gets paid, we close. But at the same time, we also close with Doug's lawyer. Okay, so we send him a statement of adjustments. We send him an affidavit, various things that he has to sign so that we can send him the balance of the $100,000, his lift. Okay, so we actually closed two deals at the same time. Like I said, remember, this is two deals, this isn't one. So Doug's going to be sitting there with his lawyer going, okay, where's my money? Okay, sign this, sign this, sign this. And sometimes you can get into some extra stuff. So let's say Doug is a non-resident. He doesn't live here. He bought the properties in China, whatever. And now we got to close with him. There's going to be a holdback on that because with withholding tax for non-residents, it's much more difficult. Now, here's another thing to keep in mind, guys. If you are going to buy one of these assignments from a non-resident, that's almost never going to happen. Not in today's world. Okay, anybody have an idea why? Okay, since 2016, remember Christy Clark put in this foreign buyers tax for BC. It's called additional property transfer tax. It's now 20%. So if somebody's buying a property, they're not a Canadian resident, not a Canadian citizen, forget the foreign buyers ban for a minute. They're going to pay an extra 20% on this. So what happens now if somebody had bought a pre-sale way back and now they're saying, well, I'm not going to close, or I can't close, or I don't want to close because I'm going to pay that extra 20%. So the federal buyer's ban, that exempts a buyer. That exempts a buyer from this ban. So if you entered into a pre-sale contract 2 years ago and you're closing now and you're not a Canadian citizen and you're not a permanent resident, fine, you can still buy it. Because this ban only came into effect January 1 this year. But sorry, let's shut this phone off here. Sorry, guys. But if that happens, so you get around the federal buyer's ban, but now you got to pay this extra 20%. So in my example, $1 million purchase, that just added $200,000 to the purchase price. Okay, so the original guy maybe lives in China, maybe lives in Russia, who knows? He says, oh, I'm going to flip this. I'm going to flip it over to Michael because Doug is the non-resident. So the developer is just going to say, no, not going to happen. Okay, why? Because what is the reason you're flipping this over to Michael? Well, I don't want to pay the 20%. That's an avoidance transaction under the property transfer tax legislation, and it's subject to big fines, big penalties, even potentially some jail time in some cases. So the developer is just going to go, no, that's not going to happen. We're not going to get involved in that because we could get drawn into this whole mess of some kind of avoidance transaction. And in fact, even now, a lot of developers, in my example with Doug living here, Michael living here, both Canadians, they're still going to make somebody sign some affidavit saying, yeah, this isn't for an avoidance purpose. Yeah, we're doing this on the up and up. Where nobody's basically trying to, basically chisel the BC government out of their share of property transfer tax. So again, just it's really dicey when you're trying to buy one of these things from somebody who's not a resident or not a citizen of Canada, because the obvious reason why they're flipping it is to avoid the tax. Okay, so you don't want to get drawn into this. You don't want to get stuck with some kind of penalty, and the developers typically just pull up. Nope, not going to happen. Okay, so just keep that in mind. So this foreign buyers ban and this foreign buyers tax, they have really made this thing a whole minefield. So always be careful, guys, when you're buying or you're acting work for somebody, and somebody in that transaction, particularly the seller, but it can be the buyer too, is a non-resident, or they're not a Canadian citizen, or they're not a permanent resident. Okay, so there just throws a whole bunch of other stuff in the pot to look at.
Well, good, Ken. Thank you.
Okay.
Any questions, guys? Armand, where are you at? You're doing these all the time. You disappear on me.
I'm here. I'm here. Everything is more clear now. Yeah, it was a little bit gray areas for deposits. Can answer all my questions.
Good, good.
Okay, well, that's great, guys. As I say, you may run across these from time to time, but don't hesitate to give us a call. Like I said, if you're going to write one up and you don't have time to call us, you can always put a clause in there saying put a subject condition that it's subject to the seller and the buyer getting independent legal advice on it. And hopefully that lawyer or notary, whoever, can clean up something that's missing if there is anything missing.
Well, great, Ken. Yeah, and guys, refer Ken early in the process. Get him to your client to retain him early, and then you've got his expert advice all along through the deal. That's thank you very much, Ken. It's been very insightful. Well done, and we'll send Ken's number out to everybody. Mike, you got anything else? Because that's about it for the meeting here.
Well, that's case in point why to use Ken and his firm, right? I mean, and Doug will share this video with all the staff and stuff like that for sure. No, thanks, Ken. Things have changed. Things keeps changing, and that's why you want somebody like Ken to be on your side of your customer to make sure that they have the best advice, legal advice that they can get in today's market. So I don't have really anything else, guys, except for I'll do quick because this meeting went long. We've got some guest speakers and events coming up. Ani's got a presentation for us. I'm getting the email today for the invite. MLA's got the same thing coming up for some new projects. Chantel Vignola's got a couple topics she wants to share in one of the Zoom meetings. Anthem wants to get a stronger relationship with us. I had them in the office last week. I'm going to go see their project, the park that's out in Cole Harbor at $3,000 a foot. So we'll see what they're doing. I heard there's no views, but we'll take a look at it. I know Paul has always got mortgage conversations and updates for us. So thanks, Paul, for keeping us informed. The renovation, we're 7 weeks behind. We're basically waiting for the stone for the bathroom and for the reception. And then once that gets done, then the custom desks get built in, and then we're up and operational. We're still dealing with TELUS, who are holding us hostage in our phone number and contract, even though that we physically moved. and their system doesn't fit in our new location. And if Ken, if you're on there, does your law firm do any of those types of fights at all, or can you recommend somebody that's good at taking on a telecommunication company that doesn't listen?
We don't, but I can certainly shoot you an email, Michael, with a couple of recommendations.
That'd be great. Thanks, Ken. And so going forward with that, guys, we've got our phone number forwarded to the answering service. When someone calls, the answering service sends me a text message. But most of the phone calls that I'm seeing, we're not getting a lot of people phoning our company number. So is our company phone number that important? I've had it for 30 years. I love the number. But if TELUS wants to hold it hostage, would it be a big deal for anybody to have a different business line attached to their signature, to their sphere of influence? Because everybody phones, I get very few phone calls that come to the office line other than people soliciting for business. So that's where we are with the phones. I like to keep it, but TELUS is saying, even though I physically moved, I still have to honor the contract in the space of the old space. Even though someone takes over the old space and puts a whole new phone system, I'm still paying for that phone system, which I outright own. So that is my update for you guys. I'm really excited about Ani. I'm really excited about MLA. I'm really excited about Anthem, who reached out to us last week, because these guys are all knowing that the market's kind of changing and they're going to need our efforts even more. So stay tuned for the upcoming pre-sale events and information sessions. And I hope to see everybody there soon. And I'm willing to bet in under 30 days, we'll be up and running here for our next in-person meeting. That will either be in the morning or the afternoon. I'll have a little wine and cheese with it as well. But that's all I got, guys. Thank you again, Ken. That was obviously very informative, and appreciate your time. Really do.
Likewise.
All right, guys.
Good luck, guys. Have a nice
Have a
day.
good
Mike,
week.
Mike,
Yeah.
I'm talking to Rob Witzman today, and I'm going to hook you up with him about the TELUS thing. He does the big contract negotiations for individuals who have had, who've been fucked over by large companies like TELUS. So I'm going to get that organized today.
Thank you.
So, all right. Okay.
Thanks. Okay. Stay well, guys.